You're driving home late at night when you see the lights in your rearview mirror. Your heart rate spikes before you even pull over. The officer walks up, shines a flashlight into your car, and asks a simple question: where are you coming from? It sounds harmless. It sounds like small talk. But that one question and how you respond to it could shape the next several hours of your life, and in some cases, the next several years. Most people believe they have to answer. They think silence looks suspicious, or worse, that staying quiet is somehow illegal. So they talk. They explain where they've been, who they were with, what they had to drink, why they're nervous, and in doing that, without ever committing a crime, they hand the officers something to work with. Here's what almost nobody tells you. You can refuse to answer police questions, not in every single scenario and not in a rude or defiant way, but as a matter of constitutional law, there is a real protected right to remain silent. The problem is that most people don't know how it actually works, when it applies and when it doesn't, and that gap in knowledge is exactly where people get themselves into trouble. So let's break down what actually happens if you refuse to answer police questions, because the answer is more complicated and more interesting than a yes or no. Start with the source of this right, because it's older than almost any other protection in the Constitution. The Fifth Amendment says, "No person shall be compelled to be a witness against himself." That's the origin of the phrase pleading the fifth. It means the government cannot force you to say something that could be used to convict you of a crime. This isn't a loophole. It isn't a technicality lawyers invented to help guilty people escape justice. It's a core structural protection built into the American legal system, designed to stop the government from squeezing confessions out of people through pressure, intimidation, or exhaustion. But here's where it gets tricky, and where most people trip up. The right to remain silent doesn't work the same way in every situation. There's a difference between a casual conversation on the street, a traffic stop, and a formal arrest. The rules shift depending on which one you're in, and the police are not required to tell you which one applies at any given moment. Picture this: an officer approaches you on a sidewalk and starts asking questions. Are you allowed to just walk away? In many situations, yes. If you're not being detained, meaning the officer has no legal basis to hold you there, you are generally free to end the conversation and leave. This is sometimes called a consensual encounter. The officer can ask, you can decline, and legally, that should be the end of it. The problem is that in real life, almost nobody feels free to just walk away from a police officer. There's a uniform, there's a badge, there's an implicit sense of authority in every question. Courts have actually recognized this psychological reality, which is part of why the law distinguishes so carefully between an officer merely asking questions and an officer legally detaining you. That brings us to the next layer, the traffic stop, which is probably the most common way ordinary Americans interact with police. Once you're pulled over, you're not free to leave. You're required to comply with certain basic obligations. Depending on the state, that generally means providing your driver's license, registration, and proof of insurance. This is not the same as answering every question the officer asks. Here's the part that surprises people. The Supreme Court's decision in Berghuis versus Thompkins from 2010 clarified something crucial about how silence works. Simply staying quiet is not automatically treated as invoking your right to remain silent in every legal context. According to that ruling, silence alone can be ambiguous, and in certain interrogation settings, if you want the protection of that right to clearly apply, you may need to affirmatively state that you are invoking it. That might sound backwards. Shouldn't silence just mean silence? But this is why legal experts consistently advise a specific verbal formula. Say something like, "I am going to remain silent and I would like to speak to an attorney." That single sentence does something powerful. It creates a clear, unambiguous, on-the-record moment where you have invoked your constitutional protection. It's not about being combative, it's about being unmistakably clear, because officers, prosecutors, and courts are all going to look back at that exact moment later. Now, here's a wrinkle a lot of people have never even heard of. In 2013, the Supreme Court decided a case called Salinas versus Texas. In that case, a man voluntarily answered some police questions during a non-custodial interview, meaning he wasn't arrested and hadn't been read his rights, but then went quiet when asked a specific incriminating question. Prosecutors later used that silence against him at trial, arguing that an innocent person would have answered. The Supreme Court sided with the prosecution, ruling that because he hadn't clearly stated he was invoking his Fifth Amendment right, his silence in that moment could be used as evidence. Let that sink in for a second, because this is one of the most misunderstood areas of criminal law. Just going quiet without saying anything at all might not fully protect you if you're in a voluntary, non-custodial conversation with police. The safest and legally cleanest move is to actually say it out loud. Announce that you are exercising your right to remain silent. Courts have treated that spoken invocation very differently from simply going mute. So now you might be wondering, does this change once you're arrested? It does, and this is where the famous Miranda warning comes in. Back in 1966, the Supreme Court decided Miranda versus Arizona, a case involving a man who was interrogated by police without being told he had the right to remain silent or the right to an attorney. He ended up confessing, and that confession was later challenged. The Supreme Court ruled that before police can conduct what's called a custodial interrogation, meaning you are both in custody and being questioned, they must inform you of certain rights. That's where you get the now iconic phrase, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney." Here's the twist that shocks a lot of viewers. Miranda warnings are not required every single time police talk to you. They're specifically required before custodial interrogation. If you're just being questioned on the street or during a routine traffic stop before any arrest happens, officers are often not legally obligated to Mirandize you first. This is one of the most common misconceptions in all of criminal law. People assume that if they weren't read their rights, any statement they made can automatically be thrown out. That is not necessarily true. If you weren't in custody, or if you weren't technically being interrogated, the Miranda requirement may not even apply, and voluntary statements you made could still be used against you. This is exactly why understanding the difference between a casual conversation and a custodial interrogation matters so much. It's also why so many people accidentally build the prosecution's case against themselves before they've even been arrested, simply by chatting, explaining, and trying to be cooperative. Let's talk about another twist, because rights are not always uniform across the country. Some states have what are called stop and identify statutes. In 2004, the Supreme Court addressed this directly in a case called Hiibel versus 6th Judicial District Court of Nevada. In that case, a man refused to identify himself during a lawful investigative stop, and the Supreme Court ruled that under certain circumstances, particularly when police have reasonable suspicion of criminal activity, some states can legally require you to state your name. Refusing in those states can actually lead to an arrest for obstruction, even though you still are not required to answer further questions beyond identifying yourself. But here's the key nuance. Not every state has one of these laws, and even in states that do, the requirement is typically limited to stating your name, not explaining your activities, your relationships, or your whereabouts. This is a perfect example of why blanket answers about your rights can be misleading. What applies in one state doesn't necessarily apply in another, and the specific wording of these statutes varies. Now, let's bring this back to something practical, because all of this legal history means nothing if you don't know how to apply it in the moment your adrenaline is spiking and an officer is standing at your window. If you're stopped while driving, you're generally expected to provide your license, registration, and insurance. Beyond that, in many situations, you are not obligated to answer questions like, where are you coming from, where are you going, or have you been drinking? You can politely decline. Something like, "Officer, I prefer not to answer questions," is not obstruction. It's not evidence of guilt in the way people fear. It's the exercise of a right that has existed since the founding of the country. If you're detained or arrested, this is where invoking your rights clearly becomes even more important. Say it directly. State that you are remaining silent and that you want an attorney. Then stop talking. Not because you have something to hide, but because anything you say from that point forward can be used, dissected, and reframed in ways you never intended. Here's a psychological trap that catches so many people off guard. Officers are trained interrogators. They know how to keep a conversation going, how to ask questions in a friendly tone, how to make silence feel uncomfortable and awkward. Many people start talking again simply because the silence feels unbearable. This isn't a character flaw, it's basic human psychology, but knowing that this pressure exists is exactly what allows you to resist it. There's another huge misconception worth correcting right now. Some people believe that refusing to answer questions will automatically be used against them in court, as if silence is basically an admission of guilt. In reality, once you're in custody and have properly invoked your right to remain silent, prosecutors generally cannot comment on that silence to suggest guilt to a jury. The Supreme Court has protected this principle for decades. The tricky part, as we saw with Salinas, is what happens before an arrest, during a voluntary conversation, which is exactly why clearly and verbally invoking your right matters so much, in every phase of a police encounter, not just after handcuffs go on. So here's the big insight, the one that ties this entire story together. Your right to remain silent is real, constitutional, and powerful, but it is not automatic and it is not passive. It requires you to actually invoke it, clearly, calmly, and unmistakably. Silence by itself might not be enough. Compliance with lawful requirements, like identifying yourself when your state requires it, is not the same as answering every follow-up question police might ask. And staying calm, respectful, and legally informed is always more powerful than either blind cooperation or hostile defiance. None of this means you should ever obstruct an officer, run from a stop, or ignore lawful commands. Physical compliance and verbal silence can coexist. You can keep your hands visible, follow instructions, and still say respectfully that you choose not to answer questions and would like to speak with an attorney. That combination, cooperation with your actions, protection with your words, is what actually keeps people safe, both physically and legally. The truth is, most people don't get in trouble because the law was unfair to them. They get in trouble because they didn't know these rules existed until it was too late, until they had already talked their way into a situation that a few calm, clear words could have avoided entirely. If this changed the way you think about police encounters, you're going to want to see what happens when officers ask to search your phone during a traffic stop, because the rules there are even more surprising, and knowing them before it happens to you could make all the difference.